All right, so good evening. Thanks to those of you who are joining live. I appreciate it. And for those of you who will watch the recording later, thank you as well. Welcome to our workshop on May It Please the Court. Let me go ahead and just give an about this workshop, and then we'll jump right to it. So this is a new workshop series that I'm starting this fall that's focused on exploring the interaction between the U.S. Supreme Court and federal, state, and or local policy and political institutions, actors, and behaviors. The live Zoom of this workshop is held every Tuesday from 8 p.m. to 8:30 p.m. And let's go and have at it. Our schedule for this workshop is over the course of 8 weeks. So in week 1, we had an overview of the judiciary, so you can watch the recording. In week 2, I went into more detail about the U.S. Supreme Court, its membership, docket cases, amicus curiae briefs, and oral arguments. And so for weeks 3 through 4, what we'll be doing is talking about a single case, hearing the oral arguments, and then discussing it at the end. So this is going to happen over a 3-week period or over 3 30-minute chunks. And then we'll start our second case right before Thanksgiving on November 16th. And that'll be the same structure, right? We'll set up the case, we'll hear the oral arguments, and then we'll discuss it. Okay. So let's go ahead and jump to week 3, 4, and 5. This is week 3. So let's look at our first Supreme Court case that we'll be focusing on and listening in on. So our learning objectives with this workshop is first to describe a mind map model for a case. Secondly is to explain the difference between a petitioner and a respondent. Next is to identify the facts of a case. And lastly is to identify the question of the case. Now, first thing I'd like to do is point out, set up this mind map model for a case. And it's essentially a hub and spoke, right? So we have the case in the center, whatever that case might be. And then we'll want to identify the following information: the name of the case itself, the petitioner, the respondent, the docket number, when it was decided or who was decided by, if it was started at a lower court, which court was it, its citation number, which is used to track it over time, the advocates for on one side or the other, whether it was granted, when it was argued, or when it was granted, when it was argued, what the facts are, and what the question or questions are of the case. So these different elements all help create the case as we know it. So essentially, instead of presenting it as a list, I present it as a mind map because I think it's easier to visually see that these are all the bits and pieces of information that you want to group together and associate with the case. From here, it gets unpacked depending on the complexity of the case itself. But for our purposes, just having this in your mind helps to visualize, okay, like when I think of a case, I want to know the name, the petitioner, the respondent, and so on. Okay. Next, what's a petitioner and a respondent? So petitioner refers to the party who petitioned the Supreme Court to review the case. This party is variously known as the petitioner or the appellant. Basically, somebody who says, I want to petition the Supreme Court to hear a case that I lost at some level, and will they take me up? Will the Supreme Court hear my case? So I need to petition them. That's why this person is called a petitioner. And it can be a person, an organization, a governmental entity. The respondent refers to the party being sued or tried and is known as the appellee. So the respondent, most of the times they won at a lower court level, like it was ruled in their favor. And obviously, if it through the court system, if it rules in your favor, you're like, I don't want to keep going to court because I won. And so the petitioner will be someone who lost and says, Supreme Court, please hear my case. And if the Supreme Court says, yeah, we'll listen to it, then the respondent has to respond to that petition before the court. So petitioner is somebody who lost the case before. Now they're asking the Supreme Court to hear their case. And the respondent is somebody who won in a court prior. And now they're having to respond to the Supreme Court if that case is taken up. Next, we have facts of the case. So facts of the case outlines the information known to the U.S. Supreme Court about a case. So things like the who, what, when, where, why, how, that's all known to the Supreme Court. It's important to note that the Supreme Court in and of itself doesn't do fact finding. They don't go and try to find more information, more evidence, more witnesses, more data, more testimony. They don't do that. What the Supreme Court is, it's looking to answer constitutional or legal questions. The facts of the case are determined far earlier in the process before it reaches the Supreme Court. So it's important that the facts of the case outline information known to the Supreme Court, and the Supreme Court does not go and find more facts. Rather, it's wanting to answer constitutional or legal questions. Now, when you think of the questions of the case is what the Supreme Court seeks to answer. And the answer to this question comes in the form of an opinion of the court. So the Supreme Court will get all this case information, then they'll schedule an oral argument, they'll hear the oral arguments, and then they'll go and deliberate amongst themselves. And then however it's voted on with amongst the 9 members of the Supreme Court, then they'll decide who writes the opinion for the court. Now, you can have all 9 members of the court say we agree, and then someone's assigned the task of writing the opinion. You might have, say, 8 agree and 1 disagrees. So the 8 will write a majority opinion, while the 1 person may write a dissenting opinion. And then you can go down, from 6 to 2, 5 to 4 in case decisions. So the question is what the Supreme Court's trying to answer. This is typically a legal or constitutional question that it's looking to answer. Now, as of October 26th, so today, this is the list of the cases that have been argued before the Supreme Court for the 2021-2022 term. Know that the Supreme Court operates in terms. So it's almost like an academic year where they'll start in the fall and then they'll end in the spring. And during that time, they'll agree to petitions to hear cases. They'll hear oral arguments. They'll deliberate internally, and then they'll publish an opinion sometime in the spring, maybe early summer. So these are the list of cases so far that the Supreme Court has heard or that's been argued before them. So there's recordings of this and that we can listen to and watch the recordings. So with that, for our first case that we'll be engaging with over this week, the following week, and the week after that is the case called Mississippi versus Tennessee. And I'll go ahead and I think I closed the window, so I'll reopen it. We'll look at identifying this information, name, petitioner, respondent, and so on. And then we'll jump right in and start listening to the case. So let's go ahead and take a look, and I'll click on this link. And for those of you attending live, I'll post the link in the chat. Let me get that here. I'll post in the chat in case you want to check it out. So let me zoom in here so we can see the information that we're looking for. So this is the case of Mississippi versus Tennessee in the 2021-22 court term. Here's the oral argument, which we'll be listening to in a few moments. The petitioner is the state of Mississippi. So the state of Mississippi asks the Supreme Court, will you hear this case? And the respondent in this case is the state of Tennessee. So Mississippi is suing Tennessee. The docket number is 143-ORWIG or original. And this case has not been decided yet, so obviously it's pending. Since it was already argued, now the Supreme Court needs to deliberate it and then decide on the opinion process. The citation is also pending since it needs to be finalized. It was granted, the petition to hear this case was granted June 10th, and it was argued on October 4th, so a couple weeks ago. The advocates are the following. So John F. Coglan on behalf of the plaintiff, and then David C. Frederick on behalf of the defendant. So Coglan represents the state of Mississippi, while David Frederick represents the state of Tennessee. And in this case, Frederick Liu for the United States is an amicus curiae in support of overruling the plaintiff's exceptions. Now, normally you would see a facts of the case here before the question, but we don't have those. So we'll have to derive them as we're listening to the case. But the 2 questions that the court's seeking to answer is the following. First, does Mississippi have sole sovereign authority over and control of groundwater naturally stored within its borders? And then secondly, is Mississippi entitled to damages, injunctive, and other equitable relief for the groundwater taken by Tennessee? Now, just so we're clear, obviously Mississippi and Tennessee are states, and they have geographic regions that are well defined. And underneath those geographic regions is called groundwater. So when you hear groundwater, it's the water that's underground in things called aquifers or in basically storage in the Earth's natural formations. The alternative is surface water. So things like a river or a reservoir would be considered surface water because that's up on or above the surface, while groundwater is below the surface. So in this case, there seems to be a dispute just based on these questions that does Mississippi have authority over its groundwater? And can Mississippi get relief for groundwater taken by another state, in this case, Tennessee? Okay, so let's go ahead and start listening to this oral argument. And what I'll do is I'll turn it on and I will mute myself so we can listen to this. You can give me a thumbs up once it starts.
We will hear argument first this morning in original case 143, Mississippi against Tennessee. Mr. Coughlin.
Mr. Chief Justice, and may it please.
Let me zoom out just a bit because I want to make sure the text shows up for us. Okay.
We will hear argument first this morning in original case 143, Mississippi against Tennessee. Mr. Coughlin.
Mr. Chief Justice, and may it please the Court. The Court should reject the Special Master's conclusion that equitable apportionment is Mississippi's sole remedy, because it's a remedy that redresses the wrong injury. Mississippi does not claim that defendants are taking more than their fair share of groundwater. Rather, Mississippi's case turns on a different question. Do defendants have the right to control groundwater while it is located within Mississippi's sovereign territory? And the Court has answered this question in Tarrant Regional Water District versus Herman. There, in considering an interstate surface river that had already been apportioned, the Court recognized an injury other than that of an upstream state harming a downstream state by taking too much water. Specifically, the Court recognized that one state may not divert water from another state's sovereign territory absent a waiver of that sovereignty. And here it's undisputed that Tennessee is diverting groundwater from Mississippi without Mississippi's permission. And they do so knowingly. In the 1960s, the U.S. Geological Survey warned them it was happening. But rather than stop, defendants opened new well fields within 3 miles of the border and substantially increased their pumping. As of 2014, when Mississippi filed its complaint, they had suctioned more than 400 billion gallons of groundwater across the border. They've increased the cost of Mississippi's own groundwater pumping. And by their own admission, defendants' pumping is draining an overlying surficial aquifer that record evidence indicates is pulling contaminants down into the aquifer at issue in this case. Now, the Special Master, in reaching its conclusions, asked whether the Middle Claiborne Aquifer was an interstate resource. This was the wrong question to ask because the answer doesn't matter. Even if the aquifer is an interstate resource, Mississippi still possesses sole and exclusive control over groundwater within its sovereign territory, as recognized in Tarrant and ensured by the Constitution. And defendants cannot force groundwater across the border without violating this sovereignty. I welcome the Court's question.
And so I just want to take a brief moment to highlight how the lawyer for the state is just setting up information and making his initial argument. What I would recommend is, if you're interested, you take some notes about like things that you find interesting or peculiar, or there's terms in there that you're not familiar with, like special master might be one. You're like, what's a special master? Is he talking about like Yoda and like Star Wars or something? No, it's a little different. So I recommend you take notes as we're listening to the case. Okay, back to the case.
Well, counsel, you seem to complain about Tennessee pumping water from Mississippi, but you admit that Tennessee does not enter across the border into Mississippi. Isn't that correct?
Well, Justice Thomas, we acknowledge that their wells are physically located.
So, but the case that you cite as an intrusion from, I think it's Tarrant or Tarrant, wasn't that a cross-border situation?
Well, yes, Your Honor, and we would say that this is a cross-border situation, too. So we certainly acknowledge that their wells are physically located in Tennessee, but the pumping is physically crossing the border, unnaturally changing the pressure levels in this aquifer.
But isn't that true of any well? I mean, let's say it was a lake, and Tennessee was pumping water on its side of the lake. couldn't you argue that technically it was drawing water from Mississippi?
I think so, Your Honor, and I think the key is what is the range of the unnatural effect that is controlling the water. And so here it's undisputed that these wells create cones of depression that are measurable, limited, and controllable and predictable. And so Tennessee is exercising control over the groundwater within that area.
But couldn't Tennessee make the exact same argument about you? Couldn't Tennessee, Arkansas, Missouri all make the same argument that whenever you pump, you're causing similar problems for them?
They certainly could, and we should be held to the same standard, Your Honor. We don't believe that Mississippi is pulling any groundwater or exercising control over groundwater extraterritorially. Certainly, if that was the case, Mississippi should be held to the same.
Lastly, and I'll be done. Do you have any cases that suggest that, or to support your argument on that point, that the mere fact that you draw from the same well without entering another state is actionable?
Well, Your Honor, I would point back to Tarrant in this sense, that Tarrant doesn't specifically say there has to be a physical crossing of the border. Tarrant focuses on the water and who's exercising control over the water. And so I would contend that here it's Tennessee exercising control over this water unnaturally while it is within Mississippi, essentially creating a vacuum and intentionally putting these vacuums right next to the border to exercise a limited area of control over water and pull it out of Mississippi into Tennessee.
Counsel, I think your position comes down to arguing that equitable apportionment is a remedy that should be used only in the case of interstate waters, in addition, to the salmon who kind of go with the flow.
Mr. Chief Justice, that's not our argument, and I think that Tarrant makes this point because Tarrant dealt with an interstate surface river that had already been apportioned, but I think the problem is equitable apportionment redresses a different type of injury. It addresses a case where states are acting entirely within their own sovereign borders. The unnatural taking of water is occurring entirely within the state's sovereign borders. This is different because this is a state crossing the border, exercising control over that resource beyond the border. So that's why I say it doesn't
what
matter.
Other cases would you, putting aside water, what other cases would you admit are subject to equitable apportionment?
Your Honor, I'm not sure, and I'm not sure that equitable apportionment should or should not apply as a concept to groundwater. I think there are reasons why, based on the nature of groundwater, it might not make sense. But I think the Court doesn't need to address that question about whether or not equitable apportionment should apply to groundwater. Because as I say, this is a different type of injury. This is an injury where one state is reaching across the border and exercising control beyond its sovereign territory.
Putting aside your reaching across the border, I mean, in the absence, you concede, don't you, that the aquifer flows from Mississippi into Tennessee?
We concede that there is some water that crosses the border, yes.
Well, I suppose then you're not saying that there's no equitable apportionment of that water.
I think, Your Honor, our point is that whether or not aquifers and groundwater should be subject to equitable apportionment is not the legal issue that we're presenting before the Court. What we're presenting is, does Tennessee have the right to control the resource beyond Tennessee's sovereign boundaries in Mississippi when Mississippi has not waived its sovereign right over control of that groundwater?
I'm not sure I understand that, Mr. Coughlin. I mean, you're not now saying that this is not an interstate water. You're conceding that it is an interstate water. Is that correct?
I don't know that we're conceding it, Justice Kagan.
You're saying that you win even if it is an interstate water. Is that correct?
That's correct.
Okay. So you're saying it's irrelevant whether it's an interstate water or not.
That's correct.
So let's assume that it is an interstate water. And you're saying that the reason you should win is because what? Because Mississippi is essentially doing something unnatural to have access to that interstate water?
I'd say, Your Honor, it's that Tennessee is exercising control over groundwater while it is located within Mississippi's sovereign territory.
Well, but Tennessee is doing things, I think you admitted in one of the questions that Justice Thomas put to you. Tennessee is acting entirely within its own borders. It is having effects on Mississippi. But that's the case with respect to people using a flowing river, that if there's a flowing river, Tennessee might be taking water from it, which has effects in Mississippi. So why is it any different?
Justice Kagan, where I would disagree with you is that Tennessee is acting entirely within its own borders. Their wells are physically located in Tennessee, but this pumping is creating a unnatural area of effect that's predictable, measurable, and controllable. And that area of effect is having physical effect, unnatural physical effect.
It's predictable, measurable, and controllable when an upstream state takes a lot of water from a river, that will leave the downstream state with less water. All of that is predictable in the exact same way that one state is harming another, and yet we turn to equitable apportionment to deal with that.
And I think, Your Honor, the difference in this case is that in all of the Court's equitable apportionment cases, the state who's, unnaturally having an effect on the water by taking and removing water is acting, and the effect of that is occurring, the direct effect of that is occurring entirely within the state's sovereign territory. And whether or not the water ultimately doesn't reach the downstream state because it doesn't flow there is incidental, whereas here there is a direct intentional effect. The purpose of pumping is to move water, and Tennessee is putting these wells next to the border, creating a vacuum and of a measurable area of effect, and intentionally pulling the water out of Mississippi and exercising control, direct control, I would say, over that groundwater while it is within Mississippi's sovereign territory. And I think
— Please explain to me how that's different from a dam. If Tennessee built a dam and put it on the Tennessee side, it's completely on its side, and it's interfering with the natural flow of water to Mississippi. So how is that different than putting a well that interferes with the natural flow of the groundwater?
Well, Justice Sotomayor, I don't know that it would be appropriate to dam a water, but the difference I would say is this, that creating a dam within your own sovereign territory is an action occurring within your own sovereign territory. The physical direct effect of it is within Tennessee, if that's what's happening. Pumping here is exercising control over the water while it is physically located in Mississippi. In the example of the dam, the physical control of the water is occurring entirely within Tennessee. Here it's occurring within Mississippi's sovereign territory, where Mississippi has the exclusive right to exercise control over the groundwater.
May I turn your attention to an issue you didn't mention, which is whether you should be given leave to amend or not. That is what the other side is pointing to as their exception. Could you tell me, you've been litigating this case for over 16 years. You started in the Fifth Circuit, you went to the district court, you went to the circuit court. Both courts told you got to seek equitable apportionment. You come here in 2010, we tell you the same thing. Now this is the third time you've done this. This time you explicitly disclaim any claim for equitable apportionment. When is enough enough? When should you be stopped from amending and seeking equitable apportionment? Assuming you lose, but it is a question that's open in this case.
Well,
it's only an assumption I'm working from, but when is enough enough?
Well, Your Honor, I think there's a recognition in equitable apportionment cases that it's prospective, and it's for future injury. It's not to rectify past injury. That's part of the reason why we think it's the wrong remedy here. We also think it doesn't redress the injury over sovereign control of water. But based on the nature of the remedy and that it is prospective only, I think there's a recognition that states should always have the right to be able to pursue that remedy, and particularly here where in the interim Tennessee continues to pull groundwater out of Mississippi. I think it would be inequitable to prevent us from.
Well, why shouldn't we just leave that question alone? Why should we just not decide this case, whatever the decision is, and not decide whether to grant permission or not? And assuming you finally say you're going to amend or do amend, let you figure out what's equitable at that time, or not?
Well, I think, Your Honor, again, setting aside the fact that we think equitable apportionment is the wrong remedy for this case.
So that begs my question,
yeah.
which if you think it's the wrong remedy, can you plead it, number one? Will you plead it, number two?
If the court disagrees with us and finds that equitable apportionment is the only remedy available to Mississippi, we would still want the option to pursue that, even if we think it would be incomplete as a form of relief. We would want to obtain whatever relief is possible for Mississippi.
Counsel, you emphasized in your answers so far the concept of physical control. These are the aquifers. In Mississippi, it's theirs to control. In the western states, they have these, wild horses or wild burros, whatever they are, and they don't obey the state lines. And they're wandering around, and let's just say they go from, New Mexico to wherever. Let's suppose that they're pests, I guess, in some places, but let's suppose they're a valuable resource. If they were in Mississippi and crossed into Tennessee, and Tennessee seized them at that point, would that be damaging Mississippi, or could Tennessee say, look, they're on our territory, they're under our physical control, we can exercise dominion over them, period?
Mr. Chief Justice, I think if they're exercising control within Tennessee, that is distinct from what's happening here, where there's control.
Well, I don't care if it's distinct from what's happening here or not. I'm just wondering if I would suggest that that's, at least in some sense, an interstate resource. Normally, under our precedents, those are subject to equitable apportionment. But you would say, under your theory, that no, Tennessee could take all the value of that interstate resource just because it happened to be in Tennessee under that particular point.
Mr. Chief Justice, I don't know the answer to that question, but I think the point is this. Whatever the limits of that sovereign control are, and we're not saying here that Mississippi's sovereign control over groundwater is unlimited. Certainly, Congress can place limits on it. This Court, acting appropriately, can place limits on it. Our point is that Tennessee may not limit it in Mississippi by exercising control over it while it is within Mississippi.
So it sounds to me like you're not going to give me an answer on the wild horses. It's an interstate resource that goes back and forth between two different states. You seem to say that if it's in one state, that's theirs. If it's in the other, it's that state's. And I'm positing a resource that migrates between the two states because some people might think that's what's at issue here.
And, Mr. Chief Justice, I apologize. Your question is whether or not Tennessee could capture all the horses.
Yeah. Whoever, in the spring or whatever, they go to Mississippi, and then in the fall they go to Tennessee. And can Tennessee say, just round them up and say they're ours?
While they're in Tennessee.
While they're in Tennessee.
I would suggest yes, they could. Whether or not they could do so to the extent that they would preclude all of those horses from going back.
Yeah, every last one they grab.
Your Honor, probably not. But I would suggest that the difference in the example you're suggesting is that which distinguishes all the Court's equitable apportionment cases from that here, which is that in the example Your Honor is suggesting, Tennessee is acting entirely within Tennessee's borders. It's not acting extraterritorially. And I'd say that is what distinguishes the case here from Your Honor's example and from all the Court's equitable apportionment.
So we're just about time, and I want to be respectful of that. So I'm going to just put a note here that we're concluding at the 13 second mark of this oral argument. And I'll go ahead and stop the recording, and we'll go ahead and have a discussion for a few minutes. So thanks for listening in. The turn to the horses really got me laughing. So next week we'll continue. We'll pick up for where we left off for 30 minutes or so, and then we'll wrap up the rest in the following week. And then we'll have a fuller discussion from then. All right, so let me go ahead and stop the recording, and we'll chit chat about it. Thanks for taking the time to listen in.